Supreme Court of Florida is now in session. Please be seated.
We now go to the third and final case on today's docket, Bush versus the state of Florida.
Good morning, Justices, Counsel. May it please the Court, I'm Nancy Ryan, representing the appellant, Sean Bush. Mr. Bush stands convicted of murder and sentenced to death before this court. May I introduce my colleague Raymond Warren, who was trial counsel at the guilt or innocence phase of the trial. He does not have a speaking role today, but has a great interest in the matter. As to that guilt or innocence phase, I would ask the court to focus on the discovery violation issue this morning. As to that issue, it is my burden to show an abuse of discretion, and once an abuse of discretion is shown, the question arises whether there is a reasonable possibility the defendant was procedurally prejudiced, and that standard is met where the record reflects a reasonable probability that either trial strategy or preparation would have been materially different, and a material difference for this purpose is one that could have benefited the defendant. For all those pronouncements, I'm relying on this court's opinions in State v. Shop and Scipio v. State. It's the appellant's position that the judge did abuse his discretion after the discovery violation was brought to Judge Malta's attention. There was a material change in the testimony we expected. Let me first, I'm confident
I'm sure you're going here, but could you elaborate on how that would have, how if you had known about that in advance, it would have changed the way you prepared for trial and what you put on the trial?
Had the defense known that the DNA expert was going to say, no, I can no longer rely, and no one can any longer rely on my deposition testimony, had we known that, well, we would have hired our own, we certainly would have hired our own expert to say, is that true? Is the old testimony, the old FDLE protocols, which witness Martin said she could no longer rely on, is it in fact unreliable just because FDLE deems it so, doesn't make it so? If our independent expert had not panned out for us, I think I'm confident that the question of whether the life offer, which sat on the table in this case for 6 years, whether that should be taken, that conversation would have taken on a renewed urgency. It was
I apologize. Wasn't her testimony, and I think this goes to what Chief Justice Kennedy was asking, wasn't the testimony of, is it Miss Martin was the DNA expert?
Yes.
At either direct or cross-examination that one of the alleles was not of the Bush family? Wasn't that the testimony that came out?
Her testimony was that it's not that easy to read. I'm relying on pages 974 to 983 of her direct examination. I had to read it myself several times before I got the complete meat of it. What she said was, in 2012, back when I tested this DNA, I would have testified that the DNA on the two items that had to have been handled at the scene, the towel over the blood and
the
hidden laptop, I would have testified that DNA on there had an allele which indicated it had to come from a man and had to come from a man who was not part of the defendant's patrilineal line.
There's nothing that undercut that testimony. What they, as I understand what she said was, nowadays, we would have found this all to be inconclusive because of the how much DNA was actually found there. But that's not inconsistent with what your side had elicited at trial and what you used in front of the jury, that there was another person, not Mr. Bush, right?
But it didn't make a great deal of difference to the state's case. It made a huge difference to the defense case. The defense counsel, Mr. Warren, had stood up first thing in opening statement and said, you will hear from the witness stand testimony from a DNA expert who says that there were items at the scene which were handled by a man who is not my client. Once that was gone, the hypothesis of innocence that someone else snuck in between 5:45 and 6:15 and did this was low in the water.
Well, I guess what I'm asking is that testimony was in fact elicited, that there's one allele that was found on the DNA on the laptop and the towel that did not come from Mr. Bush or his family, correct?
that was the 2011 conclusion. But immediately after that was elicited, counsel for the state said, let me find the exact language. Since 2011.
It says that the minor results would have been reported out as limited DNA results, not interpretable, right? Meaning I wouldn't have used them for inclusion or exclusion.
Correct. She couldn't exclude anybody any longer, is what she said. So her 2017 trial testimony was that, yes, the victim's DNA is on both those items, but that other DNA I can draw no conclusions from. I can't exclude anybody. I can't include anybody. I can't do anything with them because FDLE has changed what it looks for.
Well, the possible inference being under this new standard that it could have been your client.
Correct. Well, it wasn't somebody else. There wasn't an affirmative indication any longer that someone else was there. Our defense was heavily reliant on that. It was, of course, at all times Mr. Bush's decision whether to go to trial, notwithstanding the contents of the hard drive, in reliance on this DNA and in reliance on some evidence we didn't get in, part of the dying declaration, and we also wanted the spoliation instruction.
But the fact that someone else's DNA was on the laptop and the towel, and that person may or may not have been Mr. Bush and may or may not have been someone else, is not inconsistent with the theory that you presented, which is that someone else did it, right?
Yes, but the theory was presented in really an argument only. We didn't have the evidence that we started out saying you're going to hear.
But you could still make that argument. In fact, you did make that argument in closing argument.
Yes, Your Honor. That it was substantially less effective without the testimony we said we were going to elicit.
And yet the jury still had exactly that there was a DNA expert who testified that in 2011 that person found DNA that could not include Mr. Bush. That testimony.
Correct. Yes, that was elicited. Right. But what she immediately said was, I can no longer rely on that result. No one else. I'm paraphrasing. No one else can rely on that result.
But that paraphrase is kind of important because she didn't quite say that. What she said was, quote, and tell me if I'm wrong if I have the quote. If this had been reported today, I would still have reported out the major contributor as Mrs. Bush, but the minor results would have been reported out as limited DNA results, not interpretable, meaning I wouldn't have used them for inclusion or inclusion. That's if it had been reported, say, not that I cannot do this and I cannot do that. There was no imperative that was stated, was there?
Not expressly, perhaps, but I think the implication is clear that if FDLE has changed its reporting requirements, it has done so to make them more reliable. What other reason could FDLE possibly have for changing its reporting requirements?
What's there to undercut the finding of the trial court, which we are to defer to, as I understand it, since there was a proper Richardson inquiry here, as you've conceded?
Yes, Your Honor.
That this was a non-intentional or non-willful discovery violation.
And so the state has argued that the defense put on nothing to show it was intentional. I'm relying on the questions themselves that the state asked. Since 2011, have FDLE's policies changed in terms of how it reports out results such as this? And if this result had been reported out today, what would you have put on the report? The counsel for the state was well aware that this didn't come up in DEPA.
The trial court heard that and also heard the argument that it wasn't intentional and they didn't know, and the trial court made a finding there. How are we to undercut that finding or to find that that finding is so wrong or outside the realm of reasonableness that's an abuse of discretion?
I submit it's an abuse of discretion because of the stakes in this death case and because it was clear during opening statement that the defense was going to heavily rely on this individual who was in the room handling the stuff. It may not be a watertight defense, but it was our defense, and we were going with it. In this case...
Didn't the trial court said, after the objection is made, well, I don't know if she testified to an opinion. The opinion is that it would be no opinion essentially. And then I'll hear from the state. And then the state says that there's been no change. That all seems a little detached from what had happened because it seems like we've got the original, the testimony at the beginning of this little sequence here where she says what the report was earlier. And she testifies that to what the report showed earlier. And then we go on to what the report would be now under the current standards, and it's unquestionably different, isn't that correct?
It is unquestionably different. Clearly, Your Honor, I submit to all of you that the trial judge, Judge Moss was quite new to criminal defense at this time. I think we can all agree he's a very quick study and got a great many things right. But I do confidently
But when the state says, well, Judge, there's been no change, that's not really reflecting what has gone before. Is it?
Not at all. Not at all. There was clearly a change, and the defense was made to look foolish. Here is in the Scipio case. I submit this case has a lot of resemblances to Scipio v. State, which is another case that this office handled.
The trial court judge was actually quite careful, though, because the trial court judge did what careful judges do, which is that he said that even if there was a discovery violation, quote, but even if there was a discovery violation, it would be inadvertent. It's trivial because the witness did not testify with regards to the blue towel, that there was someone else's profile on there. I do not find it to be unfairly prejudicial. The judge went through the analysis after having an inquiry and made an alternative finding, did he not?
Yes, he did, but I submit it's unsupported by competent substantial evidence in the record, given what the state asked after eliciting the 2011 model testimony and then saying, you can't testify, saying in effect, you can't testify to that anymore, can you?
But isn't the judge's reasoning this? First of all, I'm going to find that there's not a discovery violation because all she said is that under today's standards, she would not have reported it of no report, essentially. Not that the opinion would be any different, but of no report. Well, I'm just having trouble understanding what that means.
I am as well, Your Honor. I think maybe what we said earlier, which is that there didn't make a great deal of difference to the state case, perhaps, but it made an enormous difference to the defense case. And I do ask the court to reverse the conviction altogether on this ground.
Ms. Ryan, what was the suggested procedural prejudice to the trial court at trial?
Mr. Warren said, this is my whole case, and it's our position that in conjunction with opening statement, which everybody heard, that was sufficiently clear.
But the judge, and just piggybacking on what Justice Lawson said, there was no, when the judge said, what's the prejudice, I want to analyze it, because he's going through all of the Richardson factors. There's not what you said now, which is we would have hired another DNA expert to be able to show that in fact, it could be excluded, that Mr. Bush could be excluded. What was said was, quote, this is the totality, Judge. This is the heart of the defense. This is why it appears any suspicious person would think the state prepped this witness to ask this question after deposition learned. This goes to the inadvertence or willfulness. Learned about it and didn't reveal it to us. Nothing was said about any DNA expert that would have been hired, was there?
Not specifically, Your Honor, no.
How's the judge supposed to make a finding then about prejudice, knowing that on appeal to us that would be an issue, but no suggestion is made in front of the trial court?
In this case, there's not only procedural prejudice, as I've outlined today, there was also actual prejudice in the courtroom, in the jury's presence. Here as in Scipio, the defense was made to look foolish. We have not only procedural prejudice, but actual prejudice. And the defense counsel came out great gun saying there's going to be evidence, wait for it. And then when it came, it was completely undercut. That's our position why we're entitled to a new, Mr. Bush is entitled to a new trial altogether under the Scipio precedent. We submit, if that argument fails, I would ask the court to take a very serious and close look at the entirety of the penalty phase. It was more of a death by 1,000 cuts situation in penalty phase. There was...
Before you get there, Ms. Ryan,
Yes.
could I ask you about your first issue, the sufficiency of the evidence? You argue that this is a wholly circumstantial evidence case. I believe that that's correct. In response, the state argues in its brief that there's direct evidence. You don't address that in your reply, so I'd ask you to address two things: why you think it's wholly circumstantial, but if it's not, do you think that the analysis would change under the normal standard of review in a not wholly circumstantial case? Got that?
Yes, I got all that. Direct evidence includes the presence of the DNA. This court so held in Dausch v. State in 2012, and again more recently in the case we've cited in the briefs, I believe it's called Williams.
So you now are taking the position that that is direct evidence, the presence
Yes,
of
Your
the
Honor.
defense?
I'm sorry, did I say direct? I meant circumstantial. The
Okay,
presence in Dausch and in the more recent
Right,
case,
yeah.
this court held that the presence of DNA
Is
is a
circumstantial.
circumstance
Right.
from which guilt can be inferred. Presence can be directly inferred. Guilt of what will happen there can only be indirectly inferred.
Right.
That is our position, that it is a wholly circumstantial case. And would my position change? There's got to be reasonable hypothesis of innocence. Defense was handicapped, was kneecapped as far as showing a reasonable hypothesis of innocence. I have to admit that as far as the ground one, the sufficiency of the evidence goes. But in the penalty phase, this case went in mid-2017 under the interim instructions this court had approved at that time for use in penalty phases after the legislative and case law changes of 2016. One of the changes was that the prohibition on considering sympathy has since been removed after this court's careful consideration in 2018 in how to best improve the interim instructions. In 2017, in this case, the jury was told that you may not be influenced by invidious bias or sympathy. Sympathy was put on a level with invidious bias. It's my position that in the absence of a clear clear and express mercy instruction, the anti-sympathy instruction is a problem. There's case law that says it's okay to not have a clear mercy instruction if you got the sympathy instruction. There's case law that says the reverse is true. There's case law that says from the U.S. Supreme Court that says it's okay to say don't consider sympathy. Saffold v. Parks. But I'm relying on the Supreme Courts of Washington and California, which said they've got to have one or the other.
We've never said that, though, right?
I'm sorry?
We've never said that, though, right?
No, Your Honor. No,
In fact, what we've said is, because there's never been a mercy instruction, but where the standard instructions didn't include mercy, we said it was fine to give the quote-unquote anti-sympathy instruction, right? It was Zach, I think, is one of the cases that have said that.
Zach, I believe, is from before 2009.
It is.
2009 to 2018 was when the no sympathy instruction appeared in the penalty phase instructions. It was brought over in a lump of rules of deliberation, which were added in 2008 or 2009 to the penalty phase instructions.
In Zach, though, the counsel made the same exact argument that counsel made here, which is you can't consider sympathy. In other words, the same exact thing the instruction says. And what we said there was, you don't need an instruction there. Like here, they offered to put an instruction that the jury can't consider sympathy, and what we said is that was an error, and also that counsel's admonition to the jury that you cannot consider sympathy was proper. Right?
Yes, Your Honor. The argument is permitted on both sides.
Right.
You should exercise mercy. You shouldn't exercise mercy.
Right. So isn't that exactly what's happening here?
Oh, no, instructions from the court are deemed more serious, and I think they are taken more seriously by jurors than argument of counsel.
No, of course that's the case. But if the state is telling the jurors that you are not to consider sympathy, and that's fine, and the court and the trial court there properly rejected a sympathy instruction, one that you would have here, how is that not the same as the situation we have right here?
I would submit that the distinction between the judge saying it and counsel saying it is that great, is the distinction. I'm aware, Your Honor, I acknowledge that in Reynolds, this court termed the instruction you were never compelled nor required to find that the defendant should be put to death. This court terms that the Florida mercy instruction. As I pointed out in the brief, the Mississippi Supreme Court, in the same Flowers case that's up before the U.S. Supreme Court on other grounds, looked at the exact same language and said, well, it doesn't say anything about mercy. It's not a mercy instruction. I submit it's at best a hint. The Mississippi Supreme Court said it's just a restatement of the binary nature of the choice before the jury. So, not only did this court remove sympathy from the list of improper considerations, it also removed suggestions that the jury's role is only advisory, only a recommendation. In the preliminary interim instructions that were read in this case, twice the court referred to the jury's upcoming recommendation. Those references were never explained. They have since been removed by this court from the standard instructions to be read in penalty phases. The recommendation was referred to once again in the state's closing argument. I submit to you that these unexplained references resulted in an unclear jury instruction. That question is for this court de novo, whether the jury instruction is clear. This court so held in State v. Floyd. If this court determines that the instructions were unclear, then Estelle v. McGuire sets out the federal rule for determining whether there's constitutional harm, which is whether there's a reasonable possibility that the jury applied the unclear instruction in a manner that defeated a constitutional right. And the constitutional right in question is the Eighth Amendment right to heightened reliability in the jury's results, in the jury's verdicts, findings, whatever we have now. There was an additional problem in the jury instructions which was not objected to and is still in the jury instructions, and that's the reasonableness requirement for mitigation. That was referred to in both the interim preliminary and the interim final instructions in this case. The jurors were told that mitigation is anything which reasonably indicates that death is not the appropriate sentence.
Isn't that a direct quote from the law, from the statute? Isn't that quote from...
Yes, Your Honor. The wording's in the statute, but I submit it's inappropriate for the jury instruction.
But how could a jury instruction be wrong or unclear if it quotes exactly the language that's in subsection 4 of the death penalty statute?
What the jury heard was 3 scattershot references to a recommendation which may have sown seeds of prejudice, confusion, or may have detracted from their inclination to focus on exercising mercy, to focus their individual attentions on holding out for mercy. In Pate, the case from 60 years ago that's cited in this court's Reynolds case, we think of it now as a Caldwell-Romano case because of the subject matter, but it was at the time a prosecutorial comment case. What the state said that this court deemed reversible error in Pate was that another court will fix this. It was suggested that another court will fix any mistakes we make. And then we fast forward to 2017, where a holdout has to hold out, has to stir her stumps to disagree in deliberations. It could be anywhere from hard to almost impossible for many jurors to do so. And here I suggest to you that the reasonableness requirement is a stick to beat a holdout with. The other jurors who were united in their purpose to impose death could say, you're not being reasonable.
Well, the reasonableness, though, is only in relation to mitigators, correct?
Correct.
And here we actually know that jurors did, in fact, hold out on some mitigators, that there was some that were 10-2 or 11-1. Doesn't that indicate to us, beyond a reasonable doubt, that jurors were not confused by this and understood that they didn't need to find unanimously regarding this, regarding the mitigators?
I'm sure they understood they needed to find, to make unanimous findings. It's in the verdict forms in our case.
Not unanimous as to mitigators, correct?
No. Well, I think it could have been clearer. It is more clear now in the final instructions.
But wasn't it clear here is what I'm asking?
It may not have been clear enough, but
didn't as to 4 separate or 5 separate mitigators, in fact, some jurors did dissent, and despite the instruction you're saying is confusing, that comes directly from the statute?
I'm not sure of the answer to your question. I apologize. Okay. The statutory language doesn't support the jury instruction, is my position. The statutory language has to do with the findings the judge makes in his or her order.
Right, but how could it be relevant to, if the judge is only allowed to consider those mitigators that are, quote, reasonably established by the evidence, doesn't it stand to reason that we would want to tell the jurors to only find those mitigators that are reasonably established by the evidence?
No, Your Honor. I believe that instruction is antithetical to the entire Lockett versus Ohio line of cases, which hold from the U.S. Supreme Court that the jurors cannot be dissuaded.
That just means there could be any mitigator, but it has to be established by the evidence, right? It can't just be anything you make up out of thin air.
It has to be supported by the evidence.
Right.
Yes.
So isn't reasonably established by the evidence stating exactly that?
I suggest to you, Your Honor, that it could have been not only external flack given to a life-minded juror who was arguing mitigation that wasn't deemed significant by the rest of the jury, but they could have gone to her and said that you're not being reasonable. She could have, in her own mind, said, well, I'm not sure I'm being reasonable. And there is this requirement that we've got to be reasonable. She also could have said, this is only a recommendation.
Can I ask you one other thing? How could this be harmful in any way whatsoever, or even meet the fundamental error standard, where the trial court actually credited as proven all of the mitigators that were presented at the penalty phase? In other words, the trial court said, despite what the jury found, I find they're all proven, and I'm assigning weight to all of them.
It's harmful because each juror has to clearly understand that she can stop the train at any time. And I think there's, like I said, this is death by a thousand cuts. There were several suggestions in the jury instruction and the argument. I think one of the things in the jury instructions that might have halted a life-minded juror from taking on a majority would be the recommendation language. She could have said to herself, this is only a recommendation. I heard that 3 times. It may not really matter what we do here today. And that's fatal to the heightened reliability required by the 8th Amendment in penalty phase deliberations. Which leads me to my additional arguments that the state attorney's closing argument was inappropriate on several bases, crossed a line. What I must show is that the argument complained of is so inflammatory it might have influenced the jury to return a more severe verdict than it otherwise would have. Here is in Cardona, recently decided by this court, the state sought a verdict on grounds other than that. The evidence supported it. You had the state arguing to the jury in this case that, well, the defense is being very unfair to you by suggesting that the effect on the remaining family members is going to be even exacerbated by imposition of a death penalty. The state, in effect, said, how dare you? How dare you transfer the responsibility for these terrible acts from the defendant?
Counsel, let's say I agree with you that that's denigration of the mitigation. Wasn't that not the objection, though? Didn't the objection stated here when the grounds were that the state is treating this as an aggravator, not a mitigator?
That was one of the objections. I distinctly recall that our penalty phase counsel, Ms. Peoples, was very, very adamant about mitigation being used as aggravation. As far as the unfairness, I know it was objected to. I can't exactly.
So this is at page 7589 and 90 of the transcript. And the defense counsel's going and says, counsel's going and says, and what happens, it shifts the responsibility of the consequences of this decision from your shoulders. That's the shifting responsibility. And the objection is objection, Your Honor. He's arguing a non-enumerated aggravator, and he's trying to argue that the mitigation evidence is an aggravator in this case. That's not the objection I think you're arguing to us now, which is it was a denigration of the mitigator, right? That's different.
If that was the only objection made, you are correct, Judge.
I'm just reading what's in the transcript.
But there was clearly a non-statutory aggravator argued to the jury, which is that the defendant is a survivor of a sex battery himself. The argument was who should have known better how much pain cruelty can cause. That clearly a non-statutory aggravator. I believe the court erred completely by finding that it wasn't. The state should have been rebuked. Instead, defense counsel was rebuked for speechifying.
Counsel, you have now consumed most of your rebuttal time. I will give you an extra couple of minutes, but just want you to know you're eating away at the rebuttal time.
Thank you, Your Honor. I will reserve that time.
Good morning. May it please the court. My name is Doris MEACHAM on behalf of the state. I'd like to start off with the claim number 2, I believe, the DNA that was found on the towel and the computer. Contrary to counsel, the analyst never stated that the results back in 2011 were unreliable. In fact, during cross-examination, she was asked by defense counsel, so are you saying that the tests are unreliable? And she said, no, that's not what her statement was. She testified that they were reliable and she would have sworn under oath to the results back then as she was doing now. So there was nothing wrong with the results. She hadn't changed her testimony. She still excluded the defendant as a contributor to the DNA on the towel and the computer. And defense counsel's trial strategy was not influenced at all. During closing argument, he made that argument that the DNA belonged to someone else on the computer. During the state's rebuttal, the state conceded to that. They specifically said that the DNA found on the blue towel and on the laptop did not belong to the defendant. The jury heard that. The state conceded that. The state's theory was that the quantity and the quality was so low that that was perhaps left a long time ago. This blue towel was laying on the bathroom floor in between the bathroom and the bedroom. And their theory was this could have been left by a male that was intimate with her a while ago. Who knows how long ago that DNA was left on that blue towel. So yes, it excluded the defendant, but it didn't mean that it was actually a part of the murder scene. As far as the computer, they also conceded that the DNA belonged to someone else, but again, it's a laptop. People touch laptops. We don't know when that DNA was left there, whether or not it was somebody who left it there that night or somebody that left it there weeks ago, months ago. So that was the state's position. But the jury still heard the same evidence that was brought out in the opening statement, that there was a DNA belonging to someone else.
But with this other testimony, it seems to me that was all cast into doubt, because she says, if this had been reported today, I would have, the minor results would have been reported out as limited DNA results, not interpretable, meaning I wouldn't have used them for inclusion or exclusion.
Right. They were
She
so
testified
limited,
to that,
there was
right?
no opinion. If she were
And that was
reporting it.
that's something that came in totally out of the blue. Now, whether there was prejudice and all that, that's a different question.
Correct.
But that does seem to be something that is different than what the defense could have expected to hear based on the depositions. And the idea that she can kind of come in and say, well, yeah, I said that, but I said this other stuff too, that seems to be kind of playing a little fast and loose. What am I missing with
When
that?
you take it into the context of when they were asking her questions about the DNA that was found on this object, on that object, when they specifically got to the blue towel and they asked her about the DNA, it was low quality, low quantity. The prosecutor went a little step further. Well, what are the reasons for that? What can, is it because maybe it was left there a long time ago and it had degraded? And she said, yes, that's possible. We can't pinpoint when that DNA was left there. So,
well, that all happens, but then the key question is, if this result, after she had initially testified about the inclusion and exclusion, if this result had been reported out today, what would you have put on the report?
correct.
That's the key question, right?
That is the question.
And
But then,
I mean, it seems to me to be overwhelmingly likely that counsel knew what the answer to that was going to be. That's not just a shot in the dark.
he just asked her whether or not the standards had changed as far as reporting, and she said it had, but it never changed her opinion that he was excluded from back then. She still testified to that. She still said that was reliable. He still got to argue that during defense closing. There was no harm to his trial strategy whatsoever because the jury still had that. He was excluded from the blue towel and from the laptop. And again, the reason perhaps was because there was such low quality in there. And that goes into her reporting
If the
procedure.
objection to that testimony had been that it was completely irrelevant, that would have been properly sustained, right? Whether the standards have changed are completely irrelevant.
We're going by back in 2011, she was the analyst, she did the DNA report, she excluded the defendant.
And she
was still standing by
it
that.
was clarified on cross-examination that her, whatever the change in standards did not affect the reliability and accuracy of her previous determination that that was someone else's DNA.
Correct.
That the defendant was excluded from the DNA sample that was taken from the laptop and from the towel.
Right. Nothing had changed. She was just answering a question that was presented to her by the prosecutor. Honestly, if it were reported today, would it have changed?
So that,
yes.
really, that's could be termed as prosecutorial misconduct to ask an irrelevant question to try to confuse the jury as to what is...
It wasn't she had mentioned earlier in the testimony that some of the processes had changed. I believe that was maybe a follow-up as to have things changed.
But it did, I mean, the timing did make it sound like it was new information. It did make it sound like you couldn't rely on her original determination. Now, that was cleared up in cross, but that was clearly the effect of that question and answer.
The effect of that was really not much on the jury. And the judge, as Justice Luke specified, they went through the Richardson hearing, and they found that this was not, willful. It was inadvertent. The prosecutor did not hide this. There was no new reporting done. There was no new testing done on this DNA of the towel and the computer. So it's not like they ran all these tests and they realized, oh, he wouldn't have been excluded at this point, and they kept that. This was nothing new. Nothing had changed. There was no discovery violation, according to the judge. And even if there had been, as he stated, basically she gave no opinion at all. It was of no opinion. There was no change.
Unless nobody else has questions about that, I want to ask you about the sufficiency of the evidence standard that should be applied in this case.
In this case, it's a direct evidence case. We have
what is the direct evidence?
the DNA on the bat.
Okay, so we have a case that says that DNA is circumstantial evidence, correct?
We have the case that he cites to and right with the DNA that was found on the gloves is very different from the case that we have here. On that, in that case, the glove, first of all, was not even tied to the murder. This was a glove that was left there. So it was, you had to base inference upon inference upon inference.
I mean, the fact that DNA, the defendant's DNA, was found on the bat is a fact from which the jury could infer the ultimate fact that he wielded that bat during the attack, correct?
That was the murder, one of the murder weapons.
But that's the essence of circumstantial evidence. Direct evidence would be a videotape or an eyewitness testimony that he wielded the bat. All you have to do is believe what you're seeing in the video or what that witness is saying. That's the classic definition of direct evidence, isn't it?
Right, but this is, if this was DNA evidence, and I think
look at the laptop. So are you suggesting that the DNA of someone else on the laptop is direct evidence that someone else committed the murder?
that has nothing to do with the murder. I mean, as far as
It
the weapon.
does.
That's a laptop that was left there.
Well, there are a lot of inferences you can make from that. One is the one that the prosecutor argued. The other is an inference that the defendant argued to the jury, which was because someone else's DNA was on the laptop, you should infer that someone else was present and moved that laptop underneath the cabinet or chest at the time of the murder. Now, you have a different argument to make.
Well, there's multiple inferences.
But aren't there other inferences that could be drawn, perhaps not as strong given the quality of the DNA, from the fact that the defendant's DNA was on the bat?
On a bat that he said he never touched, never knew was there.
But I mean, that's separate evidence. Just the fact of the DNA on the bat, one inference is that he touched it at a prior time. Now, that's no longer a reasonable interest, but you see, we're talking about what's the character or nature of the fact that there's his DNA on the bat. That's circumstantial with respect to the ultimate fact of whether he wielded the bat during the murder.
Well,
right?
even if you were to consider that this was a circumstantial evidence, there is overwhelming circumstantial evidence that would...
Well, I think Ms. Ryan conceded that, but
Right.
I'm asking about what the appropriate standard of review is. Should it be the special review standard for wholly circumstantial case, or should it be, as you argued in your brief, the regular standard of review?
It should be the regular standard with the DNA on the bat, on the handle of the bat.
Okay.
Is courage an appropriate basis for which to tell the jury they are to reach a verdict?
That is not the correct comment.
Answer my question
Right.
first.
Courage, no.
Okay, so it would, on its own, it would not be.
On its own, it would not.
In other words, if I said to a jury, have the courage to find the defendant guilty and to execute him or to recommend execution, that's improper, correct?
Right.
Okay.
If you take the context of what the prosecutor actually said.
Is what I said
That's right.
improper? Okay, so let's turn to what he said, which is at 7606 and 07 of the transcript. He said, I'm asking each of you to do the hard thing but the right thing, to have the courage to return a verdict that yes, and what he does is he goes through each of the verdict forms.
Right.
That yes, that there's aggravators, yes, that they're sufficient, yes, that they outweigh the mitigators, and yes, the death penalty should be imposed in this case. How is what I said and you said was improper different from what I just read to you?
Because when one is making a difficult choice as whether or not they're going to recommend the death penalty to someone, it is a difficult choice. I mean, he is stating the obvious. He is telling them, yes, you are here in a very important role, and it is a difficult choice.
Sorry, go ahead.
The term difficult choice is different from the term courage. I mean, you could acknowledge a difficult choice, which I think everybody would acknowledge in all these cases, they're difficult choices. But to suggest that to show courage by making particular findings, that seems to me to be different than talking about a difficult choice.
Not when you,
missing there?
again, when you say it's the hard thing, it is a hard thing. It is a difficult thing. He does go on to say the right thing and to have the courage. Again, all encompassing, all of these emotions that you go through. It is hard. It is difficult.
But it's
and
not
sometimes it takes courage.
But it's, as you conceded at first, it's not a proper basis in which to reach a verdict,
if
is
you
it?
just tell him it'll be very courageous of you to reach the death penalty in this case. That's not what he said.
Well, how is being courageous and have the courage to return this verdict of yes, 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 yes?
After, and I know that, but then he follows that up with the correct statement of the law. After you have heard the evidence and you've weighed the aggravators and you've found that the...
He doesn't say after you consider the evidence. He just says, what he's reading is the verdict form. He says...
If the aggravators in this case have been proven...
Hold on, counsel. He says, have the courage to return a verdict that, yes, there are aggravators in this case that have been proven beyond a reasonable doubt. Yes, those aggravating factors are sufficient. Yes, those aggravating factors outweigh the mitigating, and yes, the death penalty should be imposed.
Right.
How's that different from what you and I have conceded is improper?
Because he's still telling them to follow the law. He's setting it up to where, yes, this is going to be an emotional time for you. It is going to be difficult. And yes, sometimes it does take courage. He's not telling them which way to go. He's just setting this up as to, yes, this is a hard thing to come to. But you still have to weigh. You still have to follow the law.
Let's assume I disagree with you. What's the standard of review on this particular error, alleged error?
On this one, it would be an abuse of discretion on this.
Well, wouldn't it be fundamental because it wasn't objected to?
That's correct. It was not objected. This was not objected to. You're correct.
So, given that it's fundamental error, have we ever said that a single comment like this is fundamental error?
A single comment, not this, not like this. What the cases have found is when you've, sort of indicated that this is what they have to do. If they've denigrated the defense, if they've made it seem that not letting him go or giving him a life sentence was the wrong thing to do. That's not what we have here. We have a prosecutor who is telling them to follow the law.
Okay, what about the comment, it shifts to you, the responsibility shifts to you, and it's not fair to you. So it's not fair to shift this burden to you in relation to the argument that they're saying that he came from a bad family situation or had a bad family and you're making sympathy on him. And the comment is, that shifts the responsibility and consequences to your shoulders. That's not fair to you.
Right. In that, he was explaining weighing the mitigators and the aggregate.
How's talking about the fairness of that particular argument and the shifting of responsibility have anything to do with the weight of that responsibility?
When he goes in there, he's talking about whether or not the defendant was a victim when he was younger, and that they should, he should know. You have to weigh that.
And I'm not talking about that comment. I understand that comment, and I tend to agree with you on that. We're talking about further down. So further down, he says, and here's what's going on with that argument. Because what invariably happens when you're thinking about family that's damaged by bad choices, what begins to happen in the jury room is you begin to think about your decision, about that, how that's going to impact other people. And again, sympathy, as the judge says, cannot be a part of it. Fine. And what happens is it shifts the responsibility of the consequences of his decision from his shoulders to you. That's not fair to you. And it's repeated 2 other times.
The
Shifting and the fairness of it.
They are there because the defendant committed a crime. They are there because of what he did.
Right, but this was the mitigating factor that was there. Certainly that's the case.
He's not, right.
It's a mitigating. If you're saying that that's not fair, that mitigating factor for them to do that to you, aren't you denigrating that mitigating factor?
Not that factor. The fact that they're there and they're having to make that choice. This is a difficult choice, and I know that's not fair to you, but that's because he committed this crime. We're here because the defendant murdered his wife. We're here, you're having to make this difficult decision because of what he did. And that may not be fair to you that you're in this position, but he was not saying that that mitigator was wrong or not fair. It was the situation that they were placed in. That's why we're here, because of what the defendant did. And again, he follows that up with, that it's hard. It's hard to come to the decision whether or not you want to impose the death penalty on someone. And it's not fair to you. But that is a correct statement of why they're there, because of what the defendant did. But he's not denigrating anything that defense counsel said or any of the mitigators in this case. And again, with he should know better, again, that's considering mitigation and weighing mitigation. You want to see he had a horrible childhood and he was good to animals, but how did he treat his wife? You can use that to weigh the mitigation. He's allowed to say that. Did you have any further questions on that, or can I go to the next?
I have no further questions on this issue.
On this issue? Let's see. As far as the recommended on the standard instructions, this was the interim instructions, and recommend was still in that at the time. The standard instructions were read. The only time the word recommend was said was twice by the judge when he was actually reading the jury instructions, and as well as the prosecutor, he said it twice during closing argument, again, in context of what the jury instructions were. That was the only time it was stated. There was no harm in that. The advisory, it's still an advisory recommendation, and as you stated with the mitigators and reasonable, they were not confused. There were 34 non-statutory mitigators, and they found 24 of them. The language in there was not confusing to the jury. Were there any other questions? If there's nothing further, on behalf of the state, I would ask that you affirm the defendant's conviction. Thank you.
Briefly, I would agree with Justice Kennedy that the discovery violation was an example of prosecutorial misconduct.
I don't think I actually said that.
If that's what you meant, I
That's
agree
the
with
other
that.
bald-headed fellow down there.
I do agree with that. And this court in Payne and this court in Scipio looked to whether prosecutorial misconduct was deliberate or not.
Let me ask you this. What did the defense do to show to the judge that prejudice had been caused to the defense by the asserted discovery violation?
He said that's the totality of our case, and in conjunction with the opening statement, I submit that is clear. He said, I think the wind was knocked out of him by hearing this. It was what the client relied on to decide to go to trial for his life on.
So what exactly was said to the judge when the objection was made? I just want to get clear in my mind.
He said it's the totality, if I may.
And what page is that on?
We're looking at page...
It's page 978 through 81. I think it's towards 80 or 81.
I'm sorry.
I have it right here. Tell me if I'm wrong, if I have this wrong. This is the totality, Judge. This is the heart of the defense. This is why it appears any suspicious person would think that the state prepped this witness to ask this question after the deposition, learned about it, and didn't reveal it to us.
Yes, Your Honor, that's it, and that's at page 980. That was the argument made at that time. As I've said, this court in Pate, this court in Scipio looked at the deliberate nature of misconduct. The federal courts to this day look to the deliberate nature of misconduct.
Do you disagree that on cross-examination, counsel effectively got the witness to clarify that she stuck by her original determination that that was someone else's DNA that was on the towel and on the computer, and that he used that in closing as he would have if the second part of the testimony had never been there? And the state did not refute that. They conceded that.
I would not agree that that it's okay. what,
I mean, it
what she
was
said
clear.
on cross was, I would have testified to it then, yes, I would have raised my hand and testified to it then, but it's still out there that she can't testify to it anymore. So
She-
I
and she
don't,
did
I think
testify
cross
to it.
fixed things, I don't think cross fixed things at all.
Do you agree, your opposing counsel said that the state in rebuttal argument conceded that someone else's DNA was on the computer and the towel. Do you concede that that?
I'm sorry, could you repeat that?
I apologize, I'm sorry. Your opposing counsel said when she was up here that in rebuttal closing during the guilt phase, the state conceded that someone else's DNA was in fact on the laptop and the towel, but it didn't matter because. Do you agree with that?
No, I think that's a misunderstanding on the part of appellate counsel. I don't think that's what he said at all. I don't think anyone ever said that even now we agree that the defendant can be excluded. That was not said. That's I submit a factual misunderstanding on counsel's part. As to the Courage remark, the defendant, the counsel's not only said do the courageous thing, he said do the right thing, which is putting his own personal opinion before the jury, which is clearly improper. And as to there being a single remark of this nature, I would point to the Brooks case cited in the briefs, which say that this court look at misconduct cumulatively, whether it's objected to or not, in determining whether the proceeding was fair enough. And it's our position that the proceeding was not fair enough, the penalty phase proceeding was not fair enough for this variety of reasons I've set out, and that the guilt phase was not fair enough because of the significant surprise. I ask the court to reverse both the conviction and the sentence.
All right. We thank you both for your arguments. Court is now adjourned.